I hope my one PPT is available to all of you.
Yes, sir.
Yes,
Yes, sir.
sir.
Yes, sir.
Thank you. You see, today my topic is on plagiarism. Now let's begin with one story. As I talked at the outset, that I'm going to share with you some real life stories. Now, one real life story is, you must be knowing about Bob Dylan. Now, Bob Dylan is a Nobel laureate in music in 2017. And can you think of a person who is so creative, having a Nobel laureate, Nobel Prize winner in music? He is accused of plagiarism. Can you think of that kind of scenario in your mind? But somehow Bob Dylan was accused of plagiarism, and he lifted some of the passages of his Nobel Prize lecture from Spark Notes. Now, what is the story behind this? The story behind this is there was a journalist called author Andrea Pitzel. Now, she was examining his lecture for the new site Slate. What she found that there are striking similarities between Dylan's quotations from Herman Melville's classic novel Moby Dick and the Spark Notes version. Almost 20 references were what you call.
Tally? Nothing मुझे अच्छा.
20 references were almost having a similarity. Now, this is one example where Bob Dylan was accused of plagiarism. Now, second example is of, can you think of a person who is a protector of the integrity of higher education or the standards of higher education? He himself is found guilty of plagiarism, a vice chancellor of a university. I'm talking about Kumayu University vice chancellor, and it is on record. I have given a what you call a reference also. It is on record. Now, what happened in this case? Now, in this case, vice chancellor was Dr. B.S. Rajput. Now, what they did, he and his research scholar pick up one paper, a research paper on black holes, which was written by a professor of Stanford University. Now, what they did, they removed the name of that professor, put up their names, and got that paper published in their names, both of their names. Can you think of that a person having a stature of vice chancellor, he is accused of what you call plagiarism, and ultimately there was a committee constituted under the chairmanship of Justice R. Singh, a former judge of Allahabad High Court. He submitted 150-page report. I'm going to share that report. I hope this may be visible to all of you. I hope this is visible now. Is it visible? Please acknowledge.
Yes, sir.
Yes,
Yeah.
sir.
Yes, sir. Yes, sir.
This is just a glimpse in front of you. Just a glimpse in front of you, the 150-page report submitted by that Justice R. Singh. And he has pinpointed that certainly there is a lot of material which is copied one, which is a copied one. Just in front of you, I'm showing you just a glimpse. There is no reason to read it. And ultimately, he was forced to resign from the Kumayu University Vice Chancellor because he was found guilty of plagiarism. It was just not what you call accusation. It was proved that he was guilty of plagiarism. Right? Now, third example. Again, an example of Vice Chancellor. Dr. Deepak Painter, Delhi University Vice Chancellor. Now, story in this case is, there is one person, one research scholar who started his research on genetically modifying Indian mustard way back in 1995 with one of the supervisor, Dr. P. Parthasarthi. And unfortunately, after having a few years, almost 4, 5 years, 7 years, he left that work with Dr. P. Parthasarthi at Hyderabad. It was at Hyderabad. Came to Delhi University, started the same work. Same work from where he left Hyderabad. He started the same work, carried out the same work with Delhi University, and that too with the Vice Chancellor, Dr. Deepak Painter. And more so, story doesn't end over here. What happened? Dr. P. Parthasarthi also transferred to Delhi University. When he came to Delhi University, he found that there is some kind of work which is going on which he left, which one of his research scholar left at Hyderabad. Because without his consent, the research scholar or the other teacher cannot carry forward the same work where he has what you call left that work, cannot carry forward. But the research scholar carried forward that work at Delhi University along with the Vice Chancellor, Dr. Deepak Painter. And when he came to P. Parthasarathi came to Delhi University, he made some complaints because Deepak Painter was a research, Deepak Painter was a Vice Chancellor. There was no action on it. Ultimately, P. Parthasarathi.
Sir.
Dr. P. Parthasarathi came to Delhi, made a complaint. There was no action on it. Dr. P. Parthasarathi went to police station at Delhi, made an FIR. And Dr. Deepak Painter was arrested, no doubt, for a few moments because his lawyer got him bail. It was a brief moment, but he was arrested for it. And ultimately, the research scholar has already gone to abroad. Now the weight is there. The moment he lands in India, he's also going to be arrested. These are just 3 real life stories where persons have not only been accused, but persons have been found guilty of plagiarism also. Finally, we come to an issue. It is a case of plagiarism. And if it is a case of plagiarism, what is plagiarism? The simplest definition of plagiarism is plagiarism, the act of presenting another's work or ideas as your own. I'm taking one example of Nagendra Babu. Nagendra Babu has some idea. Let's say he has some idea. I stolen that idea, use that idea as my own without giving credit to Dr. Nagendra Babu. I repeat, Dr. Nagendra Babu have some idea. I stolen that idea, use that idea as if that idea belongs to me. Took whole credit of that idea because I'm now becoming an original author of that idea in such kind of scenario without giving credit to Dr. Nagendra Babu. If this kind of whole anecdote or episode is there, this episode will be called as plagiarism. The act of presenting another's work may Dr. Nagendra Babu's work or Dr. Nagendra Babu's ideas as your own. As your own means mine. I'm talking about on myself. The act of presenting another's work or idea as your own without giving credit to the original author or the creator of that what you call idea or work. Now, I'm going to share with you 2 documents because it is going to be a later part of mine presentation. Though there are 2 documents. One document is UGC draft 2017. What is it? UGC circulated the draft of regulations about plagiarism in 2017 for seeking opinions of different stakeholders like academicians, like research scholars. And in 2018, they finalized the regulations of plagiarism and released those documents, that document also, which I'm going to share you on in the later part of my lecture. I'm going to make some comparison also, what they proposed and what they finalized. But somehow, at this moment, just to make you more understandable about what is plagiarism, and there is one more term which you call research misconduct. Both these terms are different. Research misconduct and plagiarism. Both these terms are different. Now, what the definition have been proposed by UGC in the draft 2017, let's try to understand. There are 3 dimensions in this definition given by UGC. Plagiarism means an act of academic dishonesty and a breach of ethics. This is one dimension. Second dimension is it involves using someone else's work as one's own. That we already discussed in our earlier slide. Now, third dimension is it also includes data plagiarism and self-plagiarism. Now, question is, if we are differentiating data plagiarism and self-plagiarism from the definition of plagiarism, meaning thereby these are separate concepts, or these are a part of definition of plagiarism? That is the question. Let's try to understand here why they have used these two terms, data plagiarism and self-plagiarism. I'm building one scenario. The scenario is there are people like doctors who have already obtained a degree of PhD. There are people maybe yet to obtain a degree of a doctorate, maybe. And both of you are making some kind of research papers. Now, I'm building one scenario that you prepared a research paper which is based on your thesis, but thesis has yet to be submitted to the university. And you have published the paper prior to the submission of your thesis. Now, this is one example. I'm just building one example in front of you. Because what you are doing for your research thesis, you collect the data, tabulate that data, compile that data as per your objectives, then apply some statistical tools. Then after application of your statistical tools, you get some kind of findings, figures based as findings, and then you interpret those figures in description, final description of those found figures after application of your statistical package. The question is, if you are using your data, which you are just reproducing into your thesis as it is, what is there in paper, that is also as it is in your thesis. Condition is you have not cited your paper, because the data which is already published in the shape of a paper has gone to public domain. The data which has already gone to public domain, meaning thereby, now this data is not unique one. This data is not new one for thesis. For paper, it is unique. For paper, it is new one. For paper, it is an original one. But when you copy that data, recycle that data, reproduce that data into your thesis, which is going to be submitted later on, without citation of paper, despite of the fact that paper is authored by you. Now, up to the recycling or reproduction of the data, you will say, without citation, you will say this is a data plagiarism. Now, when you are extending your data plagiarism, now you are putting up some description also, what you call interpretation or description. Now, this description plus data, because both are owned and authored by you. This is whole your creativity of creation of content. When you are creating that content along with the data, and you are reproducing the same content, same data, which is already published in your paper, now into your thesis, which is submitted later on without citation of earlier paper. It is that concept will be known as self-plagiarism. Now, question is, do data plagiarism and self-plagiarism are a separate concepts or are a part of plagiarism? To me, they are a part of plagiarism. But here, in definition, they have shown as a separate dimension. But it was proposed. Now, question of first dimension is, plagiarism is an act of academic dishonesty and a breach of ethics. What does it mean? If you are breaching of, though I'll give you one example later on. Please underline this. At this point of juncture, I'm not giving you any kind of what you call explanation, but I'm just summing it up that this dimension is a research misconduct, which is different from plagiarism. Right? This is again a proposal, not final definition given by UGC. That definition was given by UGC in the final regulation of released in 2018. Another way of what you call understanding plagiarism is, I'm giving you two senses One sense is transitive sense. Another sense is intransitive sense. Very minute difference. What you call negligible difference, but difference is there. Very thin difference, what I say. Very thin difference. Difference is there. Let's go for transitive sense. To steal and pass off the ideas or the words of another as one's own. Use another's production without crediting source. Underline this, without crediting the source. Stealing and pass off is the common between transitive sense and intransitive sense. Now, intransitive sense is to commit literary theft. Present as new and original an idea or product derived from an existing source. You see, in transitive sense, I'm talking about, first of all, transitive sense. You are using that idea without crediting the source and don't saying that this is new and original. But when you are talking about in a transitive sense, then it is a literary theft. Maybe transitive or maybe intransitive. It is a literary theft. But when you are talking about in transitive sense, you are presenting that literary theft as new and original, an idea or a product derived from an existing source. So there is a procedural differences. There is basically a perceptive differences with regard to your procedures when we are talking about transitive sense and intransitive sense. Now this word, plagiarism, has been derived from one Latin word, what you call is plagiarism. Now, what is the meaning of plagiarism? It is the meaning of plagiarism is kidnapper. Kidnapper means you have kidnapped the idea of somebody else. Now you are using that idea of your own, for your own, taking an advantage as if the idea belongs to you. Though it is not. Though it is not. Meaning thereby, plagiarism is, it's a literal meaning of it is a kidnapper. Why plagiarism is important and who really cares for it? You see, what plagiarism is doing. What is going on? The going on is you have some kind of intellectual, what you call ideas, and those are known as intellectual property. And if somebody robs you of, this is a literary theft. Plagiarism is a theft of intellectual property. And it is also considered as a cheating. And now, gone are those days when plagiarism was going skip, persons were escaped from plagiarism. But now, regulatory bodies, monitoring bodies, your organizational bodies, they are monitoring you. They are noticing you. And if you are caught red-handed, you are going to have some punishments. You are going to have some punishments. That's why plagiarism is important. I'm showing you one cartoon. Please don't read what is written underneath. There is one person holding one jar, and in that jar, there is one object. I want to ask you, what is that object? Please use your chat box, or you can unmute yourself and we can talk. There is a person holding one jar, and in that jar, something is there. Something, some object is there. Some subject is there. What is that subject? Dr. Devyanka, please mute yourself. Dr. Devyanka, NS. Dr. Devyanka, NS. Dr. Thank you. Thank you. I noticed you. Now, you can use your chat box, please. It is a fetus, Vijayendra. Thank you very much, Vijayendra Chenoy. He commented on it. It's a fetus. Anybody else? You can unmute yourself. We can talk also. I'll have 1 minute. I want to be this session to be more interactive, because now these kind of scenarios I'm going to show you, and then I need there should be some kind of interaction. Some more is coming up. Some sample, Mamta Banur. She's saying some sample. No, which kind of sample it is? If you can explain me. It is not a sample of agriculture. It is a sample of something else. Dr. Mamta. If you can explain it.
Some biological organism sample, something.
Yeah, true.
Okay.
It's a biological, some kind of biological organ. Thank you.
Yes.
Thank you for your contribution. Anybody else? You see, there are almost 62 persons on board and very few observations. Forget those things that if you have incorrect observations, forget about that. Observation should be there. Dr. Shruti Acharya. Dr. Shruti Acharya. Can we talk? Dr. Shruti Acharya. Can you unmute? Dr. Shruti Acharya. Yeah, thank you very much. Because somebody is sitting beside you. I want you to interact with me. Now, what is there in that, what you call jar? I showed you one picture, Shruti. Have you seen that picture?
Yes, kidnapper of data. The theft of data is the plagiarism.
Okay. Hold on. I'll show you that. Hold on, Shruti. I'll show you that picture again. You kindly respond to that. This one. I hope this one the picture. There is a person holding one jar, and in that jar some object is there. That is my question. What is that object in that jar?
Sir, it is a biology test, and so he is carrying some animal inside the jar, a small one for testing. And yeah, I saw something called frizz there. So
Thank you very much, Shruti. Thank you. It was just to attract your attention to my lecture rather than talking to you person sitting beside you, right? Because I noticed you camera is open.
I'm so sorry, sir. I'm really sorry
for everything, right? Now,
sorry, sir.
Anybody else who wants to say something?
Stealing knowledge.
Sir.
Good morning, sir.
Good morning. What is there?
Yes, sir. Stealing knowledge.
Stealing knowledge. Okay. Can you think of that object is a knowledge?
Sir, it's an organism, sir.
It's an organism. It's an organism. What kind of? Let's say somebody is talking about biological. Somebody is saying it's a fetus. Can you give the name of that biological organism?
It's a reference.
Nalini, you were saying something.
Reference. It's a reference.
Okay, I take your point, but somehow I differ from your opinion. Akashta, Akshata, sorry.
Yes, sir.
You were saying something.
Yeah, sir. It's some organism. What I felt, what I observed.
Can you give that name of living organism?
Yeah, probably some lizard type of stuff.
Okay, I took it. Maybe some kind of lizard type. Done. Anything else?
So can it be somebody's mind? That's what I felt.
Okay,
Where you are trying to steal the idea from the person's mind.
Somehow. Okay. Somehow.
Brain.
Yeah.
Somebody wants to say something?
Brain, sir. Stealing brain.
Yeah, that's true. It can be. Thank you very much. Let me come back now to my screen. What is there? You see, this is a teacher showing a jar to rest of the class and saying, class, who can tell me what I have preserved in this jar? Now, somebody is saying, like you people, it's a living organism. Somebody is saying it is a fetus. Somebody is saying it's a brain. Somebody is saying it's a pig. Somebody is saying it's a baby cow. Now the response of teacher is, no, it's not a pig or a baby cow. It's the last student who got caught cheating on one of my tests. Can you think of, this is a kind of sensitization to you that gone are those days when you are engaged in plagiarism and you are going scot-free. Gone are those days. Now you should be very cautious about it because there are regulatory bodies, there are monitoring bodies, there are organizational bodies. They are noticing you. They are having a eye on you, and your whole movements with regard to your research are being under watch. That is a sensitive. This cartoon is nothing else. This cartoon is sensitizing you. Be careful in future about your research, especially about plagiarism. I have an argument also why not to plagiarize. Because people say, if I'm making some kind of copying, you do that copy. Doesn't matter. And I'm not saying you that you must not, what you call, copy it. If you are copying it, give credit to that source. Because that idea doesn't belong to you. The question is, what is that idea? The idea, I'm not going into detail, but now I'm saying you, what is the meaning of higher education? If you understand the meaning of higher education, if you understand the process of higher education, you will understand why not to plagiarize. To me, what is appearing is, there is some kind of what you call knowledge which is available to you, some kind of knowledge. In higher education, what you are doing is, you are trying to have some research study, creating some new findings, and those new findings are what? That is an addition of value to the existing knowledge. I'm repeating again. You already have some knowledge. Then you conduct some research study. Having that conducted of research study, you create some new findings. And what are those findings? Those findings is an addition of value to the existing one. 1 minute. Beta, I'm in a class online. Bye. And when you are adding that knowledge to the existing knowledge, that is the whole meaning of what you call as higher education. The purpose of higher education. How you do it? You are doing it through some educational experiences. And those educational experiences are what? You are involved in research, you are involved in thinking, you are involved in then writing, putting it into a shape that one can read it. This is for your readers. And these are the educational experiences through which you create an addition of knowledge over and above of existing knowledge. And if somebody robs you of those educational experiences, how do you feel? You will feel bad. Now, this is an emotional way of understanding why not to plagiarize. Because if I did something creatively and somebody robs me of using that under his or her name, how do I feel? I'll feel bad because that creativity has not been acknowledged by somebody else. That creativity has not been credited by somebody else. That creativity has not been recognized by somebody else. And if that is a scenario, you will feel always bad about it. And this is what you call, I'm making some kind of emotional appeal for you. And if somebody robs you of those kind of educational experiences, how do you feel? That is the reason. Please do not plagiarize. Please do not plagiarize. If there is some kind of idea you have taken from some source, please acknowledge it. Please recognize that source. Please give credit to that source. If you are not doing that, that will lead to plagiarism. Okay. Another example. You see, there is again a teacher and a student. They are contending. Teacher is saying this is a plagiarism. But student is claiming no. He's saying, really? Someone told me it's not plagiarism. If they are dead, coming back to you. If the person has died, you took up his or her idea. without giving credit to him or her. Is it a plagiarism? If somebody do not want to, what you call, open up their cameras or what you call, unmute themselves, they can use chat box. You can use chat box. Much easier. Mamta says, yes, it is a plagiarism. Okay. Mamta, can you give me a logic also?
So definitely, sir, when you have taken so much pain in, generating that idea and bringing it to the public domain, and somebody copies it from you and claims that it is his or her idea, definitely, and it is a matter of, yeah, as you said, ethics also. So yes, it is a cheating and it is a plagiarism.
Mamta,
Sir, is it
one,
unintentional
Shruti,
plagiarism?
Shruti, 1 minute, because let me respond to her. One
Yes.
issue, Mamta, which you are talking about, let me be very clear, the persons who are on the board. Breach of ethics as well as plagiarism. These are two different things. Mind it.
Okay.
Mind it. I'll give you one example. When I'm coming to self-plagiarism, a notification issued by UGC. I'll give you one example at that time. You will be having a much more clarity about it. But please bear into your mind breach of ethics, what you call research misconduct,
Okay.
and plagiarism are two different things. Shruti,
Then it is theft of idea also, no, sir?
no doubt it is a theft of idea.
Ah.
It is just not theft of idea. It is beyond that.
Okay.
It is beyond that, Mamta.
Yes.
Shruti, over to you.
Sir, the boy says that is it really plagiarism? So it may be unintentional plagiarism. He has not done it intentionally, but he has written something which he didn't know somebody else has already told it. So can that also happen?
I hope so, but
Unintentional
even
plagiarism.
if it is unintentional, Shruti, the question is, idea belongs to, let's say idea belongs to me. I expire. Somebody uses that idea without, underline this, without giving a credit to me. Even if I expired, even if I am dead, credit has to be given or not? That is first question. If credit is not given, the person is alive or dead, would you say this is a plagiarism? Question is that.
So, may I?
Shiva Swami, let me come to you. Shiva Swami M. Please unmute. Shiva Swami.
Yes, sir.
Yeah. What is your opinion regarding this? That if a person is dead and the person's citation is not given, would it lead to, because his idea has already been used, would it lead to plagiarism or not? First issue.
Of course, it is a plagiarism, sir, because he is copying his idea with maybe whether it is intentionally or unintentionally. If we are using that idea in that sense, so it should be a plagiarism.
Done. I take your point. First issue. But who will claim for it? The person is already dead.
The legal heirs of the or the publishers.
Nalini,
Yes, sir.
your point is well taken. Your point is well taken. Can you describe in detail, if you can?
The legal heirs of that particular person or the publisher, the copyrights which are reserved, or
Well, let's say if it is unpublished, the copyright is already not there, meaning thereby that part has already been ignored. It is already eliminated. Now, question is of that it is unpublished. Let's say idea is unpublished
unpublished.
and the person has died. His idea is used. This is a scenario, and you will face this scenario in your real life.
Sir, innocent till caught.
True, but somehow it is not a case of innocence. It is a case of who will claim that there is a plagiarism, that plagiarism has already happened, plagiarism has already occurred. Who will claim for? Nalini, I agree. First of all, let me compliment you. I agree that legal heirs can claim for it. How?
I'm not getting.
Anybody
How
else?
will they come to know, sir, if it is not
Sir,
published?
for example,
Sir, if it
Shruti,
is
hold
not
on.
published.
Shruti, hold on. Let Mamta is continued. I'll come
Yes,
back to
sir.
you.
Sir,
Mamta, carry on.
my question is, this one is, if it is not published, if it doesn't come to light only,
Okay.
so how do we come, how does anybody come to know whether it is a legal heirs or the publishing authorities or whoever it is, if it is not published and it doesn't come to the public domain,
All
how
right.
will anybody come to know?
All right. Shruti, you want to say something? Over to you now.
So just for an example, when there is a movie of some patriotic hero, like Mangal Pandey movie got released, and his legal heirs had problem about how it was portrayed. Like so there was some wrong information given about the person. So they claimed that is one chance, and there is one more chance that even if it is not published, somebody else has already read that work, and they know that this originally belongs to this dead person, and somebody else is claiming its originality. So then they can question. It need not be a legal heir, according to me.
Agreed.
Say,
Agreed.
suppose I have read your work, I know that it belongs to you, though it is not published. And when I get to know that it is used by somebody else, I can always file a case, I guess.
But then
Am
you
I
have,
right?
but then you have to substantiate also. If you are talking about a case, then the legality says that you have to substantiate your claims. How do you substantiate your claims? That is going to be a bigger question. Okay, I'll give you one example now. The reason behind giving me example is because I was having an additional charge of university RTA cell. It is a centralized cell of our Punjabi University Patiala, and every application which was coming to university, that was handled by RTA cell. Even there is an even there is an appeal within appellate authority, that was also handled by RTSL. And if there is an appeal to commissioner, even then it was handled by RTSL. Now that was a composition of RTSL, that was a profile of RTSL. I was in charge of that. I was also in charge of legal affairs of the university. Now, if there is a case on the lower courts, if there is a case with the high court, if there is a case with the Supreme Court, and if there are some cases of tribunals or commissions, I was handling on behalf of the university. Though I'm a lawyer also, but somehow I was not representing my university to these commissions. The representation was done by lawyers who were on our panels. But I was handling the file work, making the answerable, what you call different, I was making a bridge between lawyer and the rest of the university, so that information is reaching to lawyer. And lawyer can make our case properly in front of court. No, that was the profile. What happened? Once upon a time, it's a real case. We received one application that one book titled so and so is published by Punjabi University Patiala. Do you have a copyright agreement between author and competent authority of the university? If it is there, please provide me the copy of that copyright agreement between a registrar of the university and author of the book. Because anybody can ask it. Under RTI Act, you cannot ask the whereabouts of that person. You cannot ask the identity of that person. You can only ask that how you are going to make communication. That only thing you can ask. Beyond that, you don't have any right. You don't deserve the right to ask any identity. And unfortunately, we moved that file. 1 month gone, 2 months gone, 3 months gone. Then ultimately there was a case with the appellate authority. Again, we could not find the documents. Then there was a case with the commissioner also. But before that, the concerned department told me that we don't have any ritual of copyright agreement. Meaning thereby, there is no copyright agreement. That is clear. Then I told them that how do you publish that book? Must be some kind of procedure followed for it. Now, what is the procedure? Let me share that procedure. Author will write an application to the university. It can be vice chancellor, it can be registrar, it can be dean academic, any, along with that draft. Right? This application will come to authority, then that authority will send that draft to one department, which is called as a linguistic department. Now they will have some look on it, some look. They will not go into details of it, some look on it, whether this draft is publishable or not. The material is publishable or not. And then what they will do, they will recommend that case, make a note to the registrar that this draft needs publishing. Please make a committee who will vet that material with regard to integrity of, with regard to security of, with regard to, nothing is said about some reservation or casteism or so and so forth. Registrar will make a committee, 3, 4, 5-member committee. They will go through that draft. Finally, if there is a recommendation that this draft is publishable, then it will again come to registrar. Registrar will give a financial sanctity also that what money is to be required for publication. Those sanctions are given, and then it will go to our publication house. This is a procedure, meaning thereby the representation given by an author is implied consent to get that material published. Okay, I asked them, where is that consent? Please give me that letter which is written by that author. Finally, they gave me in writing that file is not traceable. As usual, of public sector, file is not traceable. I said, okay, if file is not traceable, please get that registered with the police. Now, there are two names, what you call DDR and what you call FIR. FIR is First Information Report, DDR is Daily Diary Register. In Daily Diary Register, you have to just acknowledge that this thing has been lost. There is no mandatory need of investigation. But in FIR, there is a mandatory need of investigation also. I asked my people, please get that DDR registered with the police station. They got it done. By that time, we received a case from Commissioner Appellate Authority, State Commissioner. We told them that the file is not traceable and this is DDR we have already done. And this answer to the application, we sent to the applicant also. Finally, it was done. After 6 months, 8 months, 9 months, or I hope year, we received a petition from Session Court of Delhi. I'll let you know the climax at the end. From Session Court of the Delhi, now claiming that this book have no copyright with Punjabi University Patiala, and how a Punjabi University Patiala can publish that book without copyright agreement. And if it is published without copyright agreement, now what is prayer? Prayer is 20 lakh compensation. One prayer. Second prayer, destroy all the books by fire in front of him. That is second. Third, few books were already sold on our publication house because there is a sale, what you call counter also in our publication house. Whatever proceeds you have already derived or accrued from sale of, that should be given to petitioner. Now, we received that petition because I was in charge of legal affairs, I was in charge of RTSL, so I could recollect that there was one case in which somebody asked copyright agreement. We went through that file, found that we have already gone for a DDR. Then again, rather than asking, taking care of that file, I asked authorities, give me the reply, para-wise reply. No, reply was simple, that there is no copyright agreement, even the file is not traceable, and this DDR is there. When I was 100% sure that this case we are going to lose, we started out of the court compromise. The proceedings were out of the court compromise. We asked our lawyer, go through it, ask him what he needs, if we can have some kind of out of the court negotiations. Finally, we concluded that case with 5 lakh compensation. We requested that fellow, please do not destroy these books, that this is a literature which is already now generated. We will give these books as charity to the, what you call, affiliated colleges. They will have in their libraries. Please let it do. Or you can take these books and give those books to some libraries at your own. He didn't allow us. He didn't allow us. We made a committee, called him, destroyed those books in front of him by fire, made a check of rupees 5 lakh, shown him that this is a rupees 5 lakh, put up that rupees 5 lakh compensation on record with the court, Sessions Court. And finally, that case was disposed of. Now, what is the conclusion? Now, the petitioner was a son of that author. Now, let me conclude now. Again, there is no case of intention or unintention. There is no case of bona fide intention or mala fide intention. There is only a case of there was a draft which was even not published. No, it was published somehow, which was not published. Legal heirs did knew about it. Legal heirs did knew about it. That yes, there is some kind of draft which has been given by my father to the Punjabi University Patala, and Punjabi University Patala has published it. Just to make a substantiation, he gone for RTI application. Got all those replies from Punjabi University Patala. Made his case a stronger one. Then he went to the court, claiming that Punjabi University Patala doesn't have any kind of document substantiating it that there is copyrights has been transferred from author to registrar. What is the climax and the conclusion of this case is legal heirs have that authority. If a researcher would claim, researcher would have to substantiate that claim with the documentary proof, not with the circumstantial proof, my dear. There are two types of evidences. One type of evidence is circumstantial evidence. You create those circumstances or circumstances are around that scene or crime scene, and then you prove it that these circumstances lead to crime. But there are documentary evidences also. You have to prove with the documentary evidence. If you don't have documentary evidence, thank you. Thank you, Vidal Singh Ganesh, Lieutenant. If you don't have that documentary evidence, please do not indulge for making wrong and fake claims. But if you have those documentary evidences, beyond legal here, one can claim, but it is in case of that person only. Right? That's how I am just making, I'm not making a Hispanic, I'm using a real life example, which I have already faced as a legal affairs in charge and as a RTI cell in charge. Now coming back again to my presentation.
Sir, sorry to interrupt, sir. Sir, if there is a vested interest, some common groups, as Madam Shruti Madam was telling, that a community for that for that matter, or somebody from somebody who has a vested interest, can they also claim, or they can also file it?
Mamta, please recall my statements.
Yes, ma'am. Yes, sir.
If you do have a documentary evidence,
Yes. If we have the evidence, I'm telling, sir.
exactly, anybody can claim.
Okay. Thank you, sir.
Because the question is, we have to identify the crime. We have to identify the criminal. Crime is plagiarism. Criminal is who did it. Right? Question is, who will do it? Author is died. Who will do it? We normally perceive that it is a responsibility of author because it is his idea, because it is his credit. Normally we say, but in case you feel that no. Even if the author has died, this is a significant contribution by the author, which belongs to whole of the community, and community have those documentary evidences with it. They can claim for it. without documentary evidences, it is my opinion, please do not move into courts. Otherwise, you are going to fail your case and it is a cost to you. So alive or dead, it does not matter. If it is not your own idea, you must cite your source. Now I'm going through some terminology like copyright. I'll discuss one term, copyright, which is given by Indian Copyright Act. I hope it is visible to all of you.
Yes, sir.
Yes, sir. Yes, sir.
Yes, sir. Yes, sir.
Second definition is, it is given by US Copyright Office. We will be able to make some kind of comparison. And at the end, I'll use both of these copyrights definitions. At the end, when I'll show you some songs. Right?
Yes, sir.
Let's go for it. First of all, copyright. Indian Copyright Act, 1957. Copyright is a bundle of rights given by the law to the creators of literary. Kindly underline this because this needs a more greater explanation. Creators of literary, dramatic, musical, and artistic works, and the producers of cinematographics and sound recordings. The rights provided under copyright law include the rights of reproduction of the work, communication of the work to the public, adaptation of the work, and translation of the work. You see, one book is given to Punjabi University Patiala because Punjabi. Let me give you one more insight. Do you know why the name of our university is Punjabi University Patiala? It is in the name of language. And Punjabi University Patiala is the world's second university which was established in the name of language. The first university in the world in the name of language is, it is in the Israel, Hebrew University. Hebrew is the language of Israel, right? That was the first university. Second university in the world which was established in the name of language is Punjabi University Patiala, right? Now somehow some book is given to us. We publish that book. But now we need to translate that book. Let's say in Punjabi. Again, we need copyright. One issue. Second issue. You have one CD which is meant for individual use, CD of any movie. But now you are reproducing that, communicating that work to the public. You cannot do it. You cannot do it because the copyright restricts you only for your own viewing. Now, coming back to creator. Let's say Mamta, one of your participants. Mamta has some kind of idea of, let's say, women empowerment. I stole that idea. Now I'm taking my example. I stole that idea, create some kind of drama on it, or some kind of musical expression on it, some kind of song on it, or some kind of what you call a picture on it. Idea belongs to Mamta. Idea is not mine, my dear. What is a Mamta in this case? Mamta is a idea generator, or maybe called as original author. What is my role? My role is I created something on that idea. What is my profile now? My profile is creator. Try to understand the loophole in copyright definition given under Indian Copyright Act 1957. Because the protection is also available to creator, maybe to the original author. Protection is available to the original author in addition to creator also, because they have mentioned the word creator. Let me go to US copyright. I hope that will give you more clarity by making differences in these two definitions. Now, US copyright says, copyright is a form of protection provided by the laws of the United States to the authors, and now underline this, original works of authorship. They are not saying creator. They are saying original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works. And the next sentence, please do read it. The protection is available to both published and unpublished work. What does it mean? This protection is available to both published and unpublished works. But in Indian Copyright Act, whatever is registered with the registrar of copyright will have protection, meaning thereby published work. If it is an unpublished work, may not have that protection. That is the difference between Indian copyright and US copyright. Second major difference is, in Indian copyright, we are talking about creators. In US copyright, we are talking about original works of authorship. Original works of authorship means Mamta has an idea. She is a original author. I stolen that idea. Use that idea for creation of some drama. One act play, multi-act play, something. I am a creator. If I move to US copyright, the protection is not available to creator. If I move to Indian copyright, the protection is available to creator also. My dear, I hope I have been able to clear the difference between original author and creator. Difference between published and unpublished work. Right? Now there is one more term which is called as fair use. Now what is fair use? Fair use is, I'll use a very limited portion of my definition. Use of limited portions of the work that has copyright without having to have permission from original author. What does it mean? I'm now using it. What is limited portion? Majority of you persons are teachers. And I hope majority of you persons are teachers from management side or commerce side, so and so forth. Taking that into my mind that you have that background of commerce and management. On the very first day, I'm a student of financial management. I'm a student of financial management. On the very first day, I went to my class, showed them a book. I'm referring the book of I. M. Pandey on financial management. I. M. Pandey. That for rest of the semester, I'm using this book, I. M. Pandey. And I'm using very limited portion out of that book on a daily basis to discuss with my students. What does it mean? Because you are using that limited portion as text, which you are transferring knowledge from book to the students, you need not to mention the name of author each and every time. You need not to give credit to the author each and every time, because you have a protection under fair use. Because you have a protection under fair use. What I mean to say here is, let's say in the midst of your semester, now some topic which is not there in I. M. Pandey book, that topic is in Khan and Jan book. On that day, when you enter into the class, you will tell the class that today you are using the book of Khan and Jan because the topic is covered by Khan and Jan, because the credit now will goes to Khan and Jan, not to I. M. Pandey. What is limited portion? One condition in this case is, in limited portion, there is no proportion defined in law. It can be 1%, it can be 10%, it can be 20, 30, 50, 60, 70. No specification. No specification. What is fair use? Fair use is use of a limited portion without to have permission from the author. If you use that, you are protected under fair use. But if you are not covered under fair use, then certainly you are going to have a permission from an author, or you have to give credit to that author, right? Coming to another part of my, what you call, talk is kinds of plagiarism. First kind of plagiarism is copying. What is copying? In this slide, you will see there is a paragraph. Starts with inverted comma, children are totally insensitive. And then it ends with inverted comma, before inverted comma, not dumb, ugly, or weak. You have copied whole of the paragraph without change in the language. When you copy that paragraph, paste that paragraph into your research study without citation. This type of plagiarism is known as copying plagiarism. Ditto, A to Z. There is no change of language. Ditto, 100% copying and then pasting into your own research study without citation. One type of plagiarism is copying. Second type of plagiarism is what you call patchwork plagiarism. Now, what is patchwork plagiarism? Again, you have a paragraph, but you change the language of few words. I have shown in blue color. Rest of the majority words remain same. You change the words, language of few words into your own language. Condition is meaning remains same. Meaning remains same is the idea of original author will remain same. Despite of the fact that you have changed the language, despite of the fact that you have modified the language, but meaning remains same. If meaning remains same, you have to give citation. And if you don't give citation, this type of plagiarism would be known as patchwork plagiarism because you have changed the language of few words. You have created a patchwork by using your own language, despite of the fact that the meaning remains same of original author. Then that type of plagiarism would be known as patchwork plagiarism. The third type of plagiarism is paraphrasing plagiarism. It is nothing, almost similar to patchwork. In patchwork, language is changed of few words. In paraphrasing, language is changed of majority words. Few words remain same. Condition, meaning remains same. If meaning remains same, despite of the fact that you have changed the majority words into your own language, but meaning remains same as of the idea, you have to give citation. And if you do not give citation, this kind of plagiarism would be known as paraphrasing plagiarism. Now, there is fourth type of plagiarism, what you call is unintentional plagiarism. I hope majority of you people are using Microsoft Office. And in that Microsoft Office, let's say I'm using one application, Microsoft Word. And when you are opening that Microsoft Word, the window, it has a ribbon on the top of it. And in that ribbon, there is one command called as reference. What I'm saying is, you are clicking that command, then again a small window will open up. And in that small window, there are a lot of columns. One column, name of the author. Second column, name of the article. Third column, place of publication. Fourth column, who is the publisher? Then date of publication. Then ISSN or ISBN number. Then what style you want to use it. You have to collect that. Maybe Harvard Business Review, maybe APA, American Psychological Association, maybe MLA, Modern Language Association, maybe Chicago Manual, so on and so forth. There are a lot many styles. You have to give that style. Once you did it, you save it. Now what will be there? This becomes a link in your running paragraph. That link will be called as quote. And this window, when you close it down, your whole document, at the end, you will have a full reference in that style. And slowly and gradually, you build up a list of those references, which will be again shown in the same window. In the same window, before you close down your Microsoft Word document. Let's say, same reference you have to use somewhere in your running material elsewhere. Now you create a link. Now you are going to tick that reference list, which is already there in that window. But when you tick it, you tick a wrong reference. Negligibly. There is no bona fide intention, my dear. There is no bona fide intention in that case. There is a bona fide intention to give credit, but giving a credit to a wrong person, that will lead to a plagiarism. And that plagiarism would be known as unintentional plagiarism. Now, in this case, try to understand. Because credit is to be given to a appropriate author. You have given a credit to a wrong author. Though your intentions were not malified, though your intentions were bona fide, that credit has to be given. Meaning thereby, this type of plagiarism is known as unintentional plagiarism. And when you are going to decide about penalty, the rigor of penalty, the strictness of penalty would be lesser. Because credit has been given. Unfortunately, credit has been given to a wrong author. Right? So this kind of plagiarism is known as unintentional plagiarism. Fifth type is plagiarism of authorship. Recall the example of Kamayu University Vice Chancellor. What they did? They removed the author of Black Holes, the professor of Stanford University, the name of professor of Stanford University for that paper of research paper on black holes, put up their name. That is what you call is plagiarism of authorship. Sixth type of plagiarism is what you call is self-plagiarism. Now, self-plagiarism is what? I have already detailed it out in my definition given by UGC. Proposed definition in UGC regulation 2017, draft 2017. What I'm saying here is that is a self-plagiarism. Now, self-plagiarism has been defined separately by UGC also. This is the document. Final regulations of plagiarism was released in 2018, but the concept of self-plagiarism was defined in 2020, 20th April 2020. This is in front of you. I hope everybody is viewing it. We will discuss in our slide. This is just for your reference. I am substantiating my claim that whatever I have taken, this is from an authorized source. Now, what is self-plagiarism?
But who
How do you,
claims plagiarism, sir? Sorry to interrupt.
yeah,
Who will claim that it is wrong? Like self-plagiarism is wrong because it's my own work. I have coded. It is wrong, definitely, but who will be claiming it?
who is there? Because I am not able to view your face. It is Shruti.
Sir, I'm Shruti. Shruti, yeah, yes, sir.
Shruti,
Yes, sir.
let me first of all
Yeah.
complete this self-plagiarism. I hope this will give you an adequate understanding about what self-plagiarism is and who can claim for it. Perhaps. First of all, reproduction in part or whole of one's own previously published work without adequate citation. Understand this. Even you have given a citation, but that is not adequate. That would be a plagiarism. Without adequate citation and proper acknowledgement and claiming the most recent work. I use these terms when I was explaining data plagiarism and self-plagiarism. claiming the most recent work as new and original for any academic advantage amounts to text recycling, also known as plagiarism, and is not acceptable. Shruti, do you know that there is a compulsion before submission of your thesis, you have to put up your research paper. You have to publish one research paper or two research paper. As per UGC guideline, there is one research paper, but universities can go for more than one research paper also. Do you know that?
Yes, sir. Yes, sir.
For making it happening that you have published that paper, you have to submit that paper along with the submission of your thesis also. Do you know that? When you are submitting that research paper and you are submitting your thesis at the stage of pre-submission, the board have every right to go through your draft of a thesis and also through the research paper content also. Anybody who finds a similarity between, between your research paper and your thesis, and if there is no citation of your paper into your research thesis, that would be treated as self-plagiarism. Reproduction in part or whole of one's own previously published work. Previously, I have given you one example that paper is published prior to submission of thesis. Right? Now, whatever is already published in paper, that data and also description in terms of your content is reproduced into your thesis. Now, because in your paper, the concept of most recent work, new and original one, has become obsolete for your thesis, because in your paper it was most recent work. In your paper it was new and original, but once it has gone to public domain, after that it has lost the significance of most recent work as new and original. Now you have to give a citation even if the paper is published by you. And if you don't do it, that will lead to self-plagiarism. Now, they have given 5 more contents to substantiate text recycling and self-plagiarism. So what are those, what you call contents? Here, I'm going to differentiate between research misconduct and plagiarism. Go for first. Text recycling, self-plagiarism includes republishing the same paper already published elsewhere without due and full citation. Please read this line. What I'm saying is, let's say a paper published by me in one journal. Let's say Academy of Business Journal. That paper is published there. I take the same paper, want to publish it again in the Indian Journal of Commerce, giving citation of my earlier paper. Same paper, ditto, 100%, A to Z. Now try to understand. Now try to understand. I have given the citation. The jurisdiction of plagiarism will be removed because I have given due and full citation. But can I publish the same paper, 100% paper, which I have already published somewhere else with due and full citation? It will be against the ethics. You can publish as per plagiarism, giving due and full citation, you can publish, but that will be shifted from the box of plagiarism to the box of breach of ethics. What you call research misconduct. Again, try to understand this definition. I'm trying to give you one example also. Text recycling is self-plagiarism because it is a recycled text, because it is a reproduction in whole of the paper, 100%, A to Z, which is already published in one journal. Now, I'm publishing the same paper in some other journal with the citation of that journal. I can get it published. I'll be out of the box of plagiarism. because then plagiarism doesn't occur. But then I'll be in the box of research misconduct. So what I'm saying is research misconduct and plagiarism are two separate concepts. Up to plagiarism, you need to have due and full citation. But when you are publishing the same paper, already published, with due and full citation, no doubt that will not be under self-plagiarism, but that will be under the research misconduct. That's how I'm trying to make differentiation between research misconduct and self-plagiarism. Now, next one. Publishing smaller and accepted work from a longer and previous without due and full citation. Meaning thereby, you have a thesis, you have almost 4 or 5 chapters. On each chapter, you create one paper. Text recycling without citation. Text recycling without citation. That will lead to self-plagiarism. Third one, reusing data already used in published work. I gave you one example that you have published a paper prior to submission of your thesis. Same data, now you are reproducing into your thesis or communicated for publication in another work without due and full. It can be taken otherwise also. You have submitted the thesis. Now, based on submission of thesis, you are getting some papers on that. Same data, which is a part of your thesis. Now you are reproducing that data for the purpose of publication without citation of your thesis. Reusing data already used in published work. Now, next one, breaking up longer and larger study into smaller sections. You have 4 or 5 objectives of your study. On each objective, you create one research paper without citation, publishing them as altogether new work without due and full citation. Paraphrasing one's own published work, meaning thereby you have changed the language, but meaning remains same. And in that case, if you don't give due and full citation, that will lead to self-plagiarism, right? Now, next one, in that
Sir,
notification,
excuse me, sir.
UGC have given self-citations do not add any number to the individual's citation index or H index in global academia. Because it will come to you by one way or the other way. Their self-citations do not add numbers to the individual citation index or H index in global academia. Now, there is an advice also. Vice chancellors, selection committees, screening committees, IQACs, and all or any expert involved in academic performance, evaluation, and assessment are hereby strongly advised that their decisions in case of promotions, selections, credit allotment, award of research degrees must be based on an evaluation of applicants' published work to ensure that the work being submitted for promotion selection is not self-plagiarized. Shruti have asked me one question that who will claim for it? Shruti, when I'm going to share with you the penalties, even if you have taken an advantage today, you can be penalized tomorrow. Even if the degree has been obtained by a student today, and after a few months or years, it was found that the degree which you obtained was based on plagiarized script, you are going to face consequences. That penalty is also there as per UGC guidelines that we'll discuss later on, right?